Thank you for joining us for today's March Law for Lunch, presented by Professor Frank Palmersheim. My name is Renee Gallagher, and I am on the State Bar of South Dakota's Continuing Legal Education Committee. And currently, as I just said, I am completing a federal clerkship with Judge Woolman. Before we get started, I have a quick PSA from Lawyers Concerned for Lawyers. Do you or another state bar member or a law student you know have a drug or alcohol problem, struggle with depression or anxiety? Lawyers Concerned for Lawyers is a confidential and independent resource for South Dakota lawyers, law students, and their families. Your referral or visit with Lawyers Concerned for Lawyers is strictly confidential and privileged. Call Becky Porter for more information, and her information was posted in the message tool in the chat bar. Becky is a Lawyers Concerned for Lawyers member, and your communication with her are likewise confidential and privileged. You can call 988 to reach a mental health professional or the Sand Creek Employee Assistance Program at their confidential crisis telephone line, which is also listed below. These providers are available 24 hours a day, 7 days a week. Today's presentation is entitled United States v. Sioux Nation of Indians Revisited, Justice, Repair, and Land Return. Our presenter is Professor Frank Palmersheim. He does not need an introduction as he is a well-known teacher, scholar, tribal justice, and poet. He has more than 40 years of experiences in the area of Indian law and policy. He is currently a member of the Rosebud Sioux Tribe Supreme Court, Flandreau Sante Sioux Tribal Court of Appeals, and the Winnebago Tribe of Nebraska Supreme Court. Thank you for joining us today, Professor Frank Palmersheim. And at the end of today's session, we will have an opportunity for us to ask questions. If you could enter your chat either publicly for all to see in the chat bar, or if you would like to individually message me, however is fine. Thank you.
Thank you, Renee. Good afternoon, everyone. I thought what I would do today, given the title of my talk, I want to start briefly by talking about the Supreme Court's decision in this case in 1980. And then from there, I want to go forward, post the decision by the United States Supreme Court, and talk about what has happened since then. And I think you'll be surprised to find out very little has actually happened since then. And if we have enough time to double back to the long history that began with the taking of the Black Hills land in 1877. So when the case reached the Supreme Court in 1980, there was one basic question before the court, and the court decided in favor of the Sioux Nation of Indians. And the question was, when the United States took the Black Hills area, 7.7 million acres in 1877, in what capacity was the United States acting? Was it acting as a trustee for the Sioux Nation in the context of being a trustee over native land? And if it was acting properly as a trustee, no compensation would be available to the Sioux Nation because it was simply a transmutation of assets. Or, on the contrary, were they acting where a second hat, the hat of the United States sovereign, where it simply took the land, exercising its Fifth Amendment right of eminent domain? And the Supreme Court decided in an 8-1 decision written by Justice Blackmun that indeed the United States was acting as a sovereign when it took the hills in 1877, and therefore it was proper for the United States to do that, except part of the Fifth Amendment eminent domain is you have to pay just compensation. And the court ruled that the United States took the land, but they hadn't paid just compensation. And so the decision in favor of the Sioux Nation was that they were entitled to just compensation. And the lower courts had decided that that was approximately, in 1877 terms, $17.5 million with interest running since 1877. And in 1980 terms, that drove the figure over $100 million. And that was it. There was an interesting and kind of wild dissent by Justice Rehnquist, where his view seemed to be everybody's a bad guy and don't worry about it. And he actually closed his opinion with the phrase, "Judge not that ye be not judged." A very strange observation for a judge to make, but nevertheless, he made it. And so that was a decision. And so normally we would think, well, the United States wrote the check and the case was closed. But in the curious world of Indian law, that's not the way it works. There is another statute called the Distribution of Judgment of Funds Act that specifically says when there's a decision in favor of an Indian tribe against the United States that emanates from the Indian Claims Commission or the Court of Claims, as this judgment did, before the money is actually paid out, the Department of Interior is charged with the responsibility of drawing of a distribution plan. How is this money to be sent by the tribe that is to receive it? Also, part of the plan is to include whether there would be any pro rata distributions to individual tribal members. And that plan is supposed to be drawn up within 180 days. So that was the initial charge that the Secretary of Interior faced. And it involves also the obligation of consultation with the tribe. And here there's 8 tribes involved. And so the secretary began that work. And I can remember vividly at the time when the secretary was going to come to Pine Ridge to visit the Oglala Sioux tribe to discuss this distribution plan. My recollection is that the tribal council of the Oglala Sioux tribe passed a resolution saying that the secretary wasn't welcome and he would not be received on the reservation to help with this distribution plan. So all of a sudden it seemed like the tribes were not interested in participating in any distribution plan for various set of reasons. I think the main one was that there was concern if they accepted the money, how would that affect any kind of possible land return? And so this distribution plan, which was supposed to be prepared in 180 days, was never prepared and hasn't been prepared to this day. So that judgment, that 1980 judgment, is just sitting today still in the United States Treasury, drawing 5% interest as required in any takings case. So the first thing to see, because I think a lot of people don't really realize that that money has never been paid out. It's just sitting there. And some people say the figure now is well past several $100 million and might be actually approaching $1 billion. But it's just sitting there. And we'll come back to that. And so in the aftermath of that initial kind of thing that happened after the decision was made in 1980, there was a growing perception in Indian country that if anything was going to happen to effectuate some kind of land return, a statute would have to be passed by Congress to effectuate any particular land return. So a number of concerned Lakota people began to try to put together a bill to present to Congress to see if indeed a statute could be passed that would involve, at least in part, some kind of land return. And a group that worked on it was generally referred to as the Sioux Nation Black Hills Steering Committee. And in 1985, they had prepared a bill. And the title of that bill is the Sioux Nation Black Hills Act. And in that statute, it called for significant land return. It called for significant compensation. It even set up a governing scheme about who would govern the land when it was returned. It specifically talked about creating a sacred space for Lakota people to have the opportunity to worship in complete privacy. And so that statute was drafted and prepared. So the next step for Lakota people was to get someone to sponsor it in Congress. That's the way that process actually works. And the problem was that at that time, we're talking 1985, no one in the 3-person congressional delegation was willing to sponsor that bill. So the Great Sioux Nation people were stuck in a way with a bill that was drafted, but they had no sponsor within their own state. So what did they do? Well, fortuity intervened in a way because there was a senator from New Jersey, Senator Bill Bradley. Some of you older folks might remember him as a well-known basketball player who played for the New York Knicks before he became a senator from New Jersey. And during his time as a basketball player, he had come to Pine Ridge and Rosebud and put on some basketball camps. And so a number of law culture people knew Senator Bradley, and they approached Senator Bradley and asked him if he would sponsor the bill, whether he would sponsor before Congress through the Senate the Sioux Nation Black Hills Act. And Senator Bradley agreed to do that, and it was done. So the bill was presented in July 17th, 1985 by Senator Bradley, and it was referred to the Senate Select Committee on Indian Affairs. And once it went to the Senate Select Committee on Indian Affairs, I guess we might say it just died there. The committee, to my knowledge, never had any hearings on the bill. They never voted on the bill. The bill never made it to the Senate floor. It just kind of died. And then slowly but surely, discussion about the Black Hills remedy seemed to kind of disappear. And here we are, by my count, 44 years after the judgment, and no money has been paid out, no land has been returned, and no other remedy has been effectuated. So it's a kind of a strange case where the prevailing party has yet to receive the benefits of any particular remedy. And I think that's something that should concern people in general. And so one of the goals of this talk and a paper that I'm working on with a colleague is to see, is there any way to rejuvenate discussion about how to deal with the Black Hills issue? And one of the possible ways involves the following: that in recent years, there's been this notion of land acknowledgement statements. And land acknowledgement statements are statements made by anybody, usually churches, universities, other public groups, saying that they acknowledge, in whatever area they're in, the presence of indigenous people, the presence of tribes that may have some interest in land issues. And the acknowledgement involves some effort to be supportive of indigenous people and their issues. And so the way that I've been thinking about it is maybe it's a timely avenue to use the land acknowledgement process to approach groups that have provided land acknowledgement statements, ask them about what they know about the Black Hills case. Are they interested in talking about it, visiting about it, learning more about it, engaging in conversations with Native people, perhaps even with tribes, about how tribes are thinking about the Black Hills case in the year 2024. So the goal is to try to rejuvenate concern and discussion about the Black Hills case, with the starting point being, despite the fact that the Sioux Nation Indians prevailed in 1980, nothing has really happened since. And that can't possibly be just. And so from my point of view, it's a continuing injustice that needs to be addressed. And hopefully, and the best way to address it, I think, is by having sort of public discussion about the issue. People become informed or re-informed about the current status of the Sioux Nation case, and see if meaningful conversation and exchange can be developed about getting Congress maybe to talk about and pass another bill. So that's the essential goal. And that was just kind of a snapshot of what has happened since 1980. There's been no distribution of the money judgment. There's been no distribution, not even any discussion of any kind of land return. And so that injustice that originates with the taking of the Black Hills in 1877 remains. 44 years with nothing happening. 2 generations of people have, both native and non-native, have lived since the judgment. And there's a concern about what do people actually know about the case and its aftermath today. And perhaps it's timely to try to engage in a new, meaningful, and respectful conversation. So that's a quick kind of view of the 44 years since the judgment by the Supreme Court in 1980. But now maybe let's switch our focus a little bit to how the case actually came to be. And the dispute and the taking of the Black Hills is rooted in the Fort Laramie Treaty of 1868. And the Fort Laramie Treaty of 1868 was a treaty between the Great Sioux Nation and the United States, in which the United States recognized that the Great Sioux Nation had the territory of what we call the Black Hills. And in particular, the boundaries are set out in Article 2, which includes all of the Black Hills. And in Article 12, there's a specific statement that if there was to be any future land cessions by the Great Sioux Nation, it would have to be approved by 3/4 of the adult male population. So that's what the Fort Laramie Treaty says, and it's critical. But soon after the Fort Laramie Treaty of 1868 was entered into, what happened? The infamous General George Custer led a scientific expedition into the hills, and gold was discovered. And once gold was discovered, not surprisingly, maybe all bets were off. There was immediate pressure for the United States to somehow become the recognized owner of the Black Hills so that non-Indian miners could come in. And so what was the approach of the United States to this challenge? Well, first, in good faith, I believe, they tried to comply with the treaty. The federal government, acting through the executive branch, appointed a commission, the Allison Commission, with the charge to come out to the Dakota Territory, to meet with Lakota leaders and people and try to get approval for the sale of the Black Hills. And the Allison Commission came out. They met with Lakota people. They had a certain money offer on the table, but it was turned down by Lakota people. There was no approval by 3/4 of the adult male population. And they went back to Washington, and the Allison Commission reported its failure to reach an agreement for cession of the Black Hills. So the federal government, after taking a deep breath, thought it would try again. And it sent a second commission out called the Many-Penny Commission with the same charge. This time, they weren't really offering any money whatsoever. They would just continue to provide annuities that they were already obligated to provide. And the Many-Penny Commission came out, and they tried to get approval of 3/4 of the adult male population. And not surprisingly, they also failed to get approval of 3/4 of the adult male population. And they reported that back to the executive branch. So all of a sudden, finally, the executive branch arguably was at a fork in the road. They tried twice in good faith to comply with Article 12. They failed both times to get approval of 3/4 of the adult male population. What should they do? Well, what they decided to do was to just go forward. And they took the proposed agreement of the Many-Penny Commission and just passed it unilaterally into law in violation of Article 12 of the treaty. But Congress ratified the Many-Penny Commission offer, and that was in 1877, and that effectuated the taking of the Black Hills. So in 1877, in violation of the treaty, Lakota people were faced with the challenge, what can they do? And so we might think, well, of course they wanted to sue, and they should have sued right away. Well, yes and no. It just wasn't that easy, because the problem was that the Court of Claims, which allowed suits against the United States, was established in 1855. Okay, that's good. But in 1863, Congress passed a law that said that the Court of Claims would not have jurisdiction over any Indian claims, any tribal claim. So when the land was taken in 1877, there was no legal opportunity for recourse. The Court of Claims was blocked by the 1863 statute. So the first work that Lakota people had to do to get into court was to get Congress to pass a jurisdiction statute that would obviate the bar created by the 1863 statute. So it took from 1877, when the land was taken, that jurisdiction statute wasn't passed until 1920. And so finally, it was only in 1920 when Congress passed a special jurisdictional act that the Great Sioux Nation would have an opportunity to sue the United States. And so the historical litigation begins in 1923. And the Great Sioux Nation is represented by a local attorney from South Dakota by the name of Ralph Case. And he files a lengthy complaint with many causes of action, as many as 23 or 24 causes of action against the United States. But the first piece of work that had to be done, because many of the claims were based on things that the United States allegedly promised to do, but hadn't done. And so the initial thing was the need for an accounting, to get an accounting from the United States with what it had done about these many claims against it. And it took over 7 years for an accounting, for just 2 years to be prepared. And that accounting consisted of 7 volumes of records of what the federal government had done. But finally, the Court of Claims heard these many claims, including the Black Hills claims in particular. But finally, in 1942, the Court of Claims dismissed this action by the Sioux Nation, claiming largely that it wasn't a remediable legal claim, but it was simply a moral claim. And as a moral claim, the Court of Claims didn't have jurisdiction to do anything about this moral claim. The Court of Claims in 1942 relied very heavily on an infamous case decided by the Supreme Court in 1903, Lone Wolf versus Hitchcock. And Lone Wolf versus Hitchcock stands for the proposition that the United States could unilaterally abrogate treaties, and that those abrogations would be perfectly legal and not really challengeable in court. So this is what I would call strike one, that the Great Sioux Nation loses before the Court of Claims in 1942. It appeals to the United States Supreme Court, and cert is denied in 1943. So from 1877 to the first adjudication in 1943, the Great Sioux Nation loses, cert is denied, and it looks like the case is lost for good. That the Great Sioux Nation has had its day in court, it's lost, and that's that. But strange things happen. So despite this loss in 1942, 4 years later, in 1946, the United States passes a new statute, and this new statute created a new administrative body called the Indian Claims Commission. And the Indian Claims Commission was to have jurisdiction over any claim by any Indian tribe against the United States involving any treaty claim, a taking claim, claims that sounded in contract or tort, and unfair and dishonorable dealings. So if the Court of Claims loss was strike one, here was a second opportunity for the Great Sioux Nation to bring a second lawsuit, this time in the Indian Claims Commission. And at this time, Ralph Case was still the lawyer for the Great Sioux Nation, and they brought their claim before the Indian Claims Commission. Unfortunately, the Indian Claims Commission in 1954 dismissed this claim by the Great Sioux Nation based on alleged lack of evidence. And so in a second opportunity, there was an initial loss in the Indian Claims Commission. Again, the Great Sioux Nation appealed to the Court of Claims, and the Court of Claims affirms the dismissal by the Indian Claims Commission. Now, right about this time, the Great Sioux Nation gets a new attorney, and that attorney, instead of filing a motion for cert for it to be heard by the Supreme Court, files a motion in the Court of Claims saying that the Great Sioux Nation had been deprived of adequate counsel. And surprisingly, the Court of Claims granted that motion for inadequate representation and gave the Great Sioux Nation a second opportunity to have their claim heard by the Indian Claims Commission. So it's actually now the third opportunity to litigate the case. And this time, for the first time, the Great Sioux Nation is successful before the Indian Claims Commission. The Indian Claims Commission decides that there was a taking, an illegal taking under the Fifth Amendment, and decides that there should be a monetary payment for that. It was decided roughly at the time of the taking. A lot of the hearing before the Indian Claims Commission was to decide how much the land was worth that was taken in 1877. And the figure that was agreed upon or found was roughly $17 million, plus, as I've indicated before, the interest. And so for the first time, the Great Sioux Nation actually prevails in its third time to litigate the issue, and the second time before the Indian Claims Commission. So they prevail in the Indian Claims Commission, and the United States appeals that decision to the Court of Claims, seeking to argue that that claim, that decision by the Indian Claims Commission should be reversed based on the grounds of res judicata, based on the 1942 decision by the Court of Claims. And so it looks like the Court of Claims is going to rule and reverse the decision of the Indian Claims Commission based on res judicata. And then yet another surprising, somewhat amazing thing actually happens, that there is a hiatus in the case as the Court of Claims is sort of dealing with the issue of res judicata, when there is an attempt, which actually turns out to be a successful attempt, and our own Senator Jim Abourezk was critical in this, that there was a bill prepared by the Great Sioux Nation, and Jim Abourezk put it in play in Congress to pass an amendment to the Indian Claims Commission Act, allowing this case to go forward before the Court of Claims without the defense of res judicata. And surprisingly, after a lot of politicking and going back and forth, Congress actually passed this amendment to the Indian Claims Commission Act, which took the defense of res judicata off the table. Really quite surprising and amazing. So now the Court of Claims was looking at this case, and the success of the Great Sioux Nation before the Indian Claims Commission, without having to be concerned, and in fact directed not to be concerned with any defense involving res judicata. And as a result of the defense of res judicata being, in a sense, taken off the table, the Court of Claims actually affirmed the decision of the Indian Claims Commission that there had been a Fifth Amendment taking of the Black Hills. And then the United States appealed to the Supreme Court and led to the case that I opened my comments with that was decided in 1980. And so when you think about that history from the taking in 1877 to the Supreme Court's decision in 1980, it's kind of like almost like three strikes kind of thing that the Great Sioux Nation lost in round one in the Court of Claims. It lost a round two in the Indian Claims Commission. It looked like it was out, but there was a successful motion to get a third crack before the Indian Claims Commission based on ineffective assistance of counsel, and that motion was successful. And then for the first time, the Great Sioux Nation was successful before the Indian Claims Commission. And when it came up to the Court of Claims, and it looked like it was going to be reversed, in fact, it was reversed on the notion of res judicata through largely through the support of Senator Jim Aberes. Congress passed a statute that took the defense of res judicata off the table, and the Great Sioux Nation prevailed before the Court of Claims and eventually prevailed before the United States Supreme Court. And so those are kind of the two sides of the case, going from 1877 to 1980, 103 years. It took for the case to go through three different iterations before it was successfully found in favor of the Great Sioux Nation in 1980. But then you might have thought, as I began my remarks with, that the case would actually be over now, that the money would have been paid and we would have passed from that particular situation. But as I've indicated, since the decision in 1980, there has been no remedy. The Great Sioux Nation does not appear to want to take the money standing alone. And so no money has been paid, no land has been returned, and no other remedy has been provided. And the way I want to think about it is that the case is incomplete, still rife with injustice, and maybe this might be an opportune time through and looking at the land acknowledgement process to generate a renewed conversation in our state by all sorts of communities and talking with and seeing how the individual tribes actually think about this. So it's an amazing case before, and it remains an amazing case after the decision of the Supreme Court in 1980. And I don't know if there are some questions out there, but those are kind of things that I wanted to emphasize.
Yes, thank you, Professor Palmersheim. Like you said, now we're going to begin with some questions. Feel free to enter them in the chat if you have any. One question that we did have is regarding how you said one of the ways that we could talk about this is rejuvenate the discussion is having a discussion of or a forum among people. How would you recommend having those open discussions with people if someone's interested in rejuvenating these conversations?
Well, I would think it's a starting point. I mean, anybody can try to start a conversation, but particularly groups, churches, universities who have land acknowledgement statements might use their land acknowledgement statement as a basis of saying it is aware that the Black Hills case has never fully been resolved, and they want to meet and talk with people within their own institutions, begin to talk with Native people, and try to be more informed about this history that I've described, and in conversation with Native people, Native groups, tribes. Can a new common mission emerge about what needs to be done? And I think institutions, churches use South Dakota Humanities Council that have land acknowledgement statements can use those statements as a basis for encouraging conversation about the Black Hills. How much do people who have passed land acknowledgement, how much do they know about the stuff that I've just laid out? I'm guessing not too much. And so it might be a first step for those kind of groups to educate themselves about the history to get a sense of what has happened, what hasn't happened, and the most important thing, that there has been actually no justice provided in the case. And can that generate a conversation within those communities and with Native communities about what might actually happen? Because as far as I can tell, there's been no public discussion, certainly in non-Indian communities, ever since the case was decided. And I think it's an opportunity, perhaps a challenge for non-Native communities to kind of step forward and say, yeah, we have to learn more about this to see if there's some basis for going forward to achieve a kind of justice in this case. Because again, despite the victory in 1980 before the Supreme Court, justice hasn't been rendered. And I think it's an important thing. It's important, of course, to keep in mind the Black Hills is not only Lakota land, I mean, it's their most sacred place. And so it's not just land in the ordinary sense, it's the place where Lakota people believe they come from. It's sacred and holy, making it arguably even more important that there be an attempt to see if some of that land can be returned. And it's important to also keep in mind, because I know sometimes over the years when I've spoken about this issue and when you talk about land return, a lot of non-Native people get immediately nervous, because if they own land in the Black Hills in this original taking area that was taken in 1877, they fear that the Great Sioux Nation wants to take their land away from them. And I think it's always been true that the Great Sioux Nation has never indicated that it wants to take land back or away from non-Indians. The land that it's generally talking about is the land that's still owned by the federal government in the hills. I think the latest figures I had seen of that original 7.7 million acres that was taken in 1877, it's still true today that approximately 1.2 million acres is owned and controlled by the federal government. And I think the Great Sioux Nation would be focusing on that land for possible return. It has never articulated any desire to take land back or away from non-Indians. And I think that's an important thing to get out there so that non-Indians don't feel challenged on it, that they might lose some land that their family had purchased in good faith back in the day.
Thank you for answering that and including the end on people's worry on what would happen on their own individual land. The next question that we received is, if one or more of the tribes wanted to collect on the award/judgment, how does that happen and who decides that? Would the entire Sioux Nation have to agree to collect?
I think so. That's one of the problems, because the reality of what has happened, which I think the person asking the question knows, which I didn't mention in my own comments, but it's important to point out, that the plaintiff in the case was referred to as a Sioux Nation of Indians, as a unified entity. But today, that's no longer a legal entity, the Sioux Nation of Indians. It's not a matter of getting money to this one entity. That one entity is now considered to be 8 distinct federally recognized tribes. 6 West River tribes in South Dakota: Rosebud, Pine Ridge, Standing Rock, Cheyenne River, Crow Creek, and Lower Brule. It also includes the Santee Sioux in Nebraska and the Fort Peck Sioux in Montana. So this, I think, would be something that hasn't been confronted before. Could a single tribe say it was interested in the money, and could the secretary prepare a distribution act for that one tribe, and how you would decide how much of that big amount that one tribe would be entitled to? I don't think the secretary has ever confronted such an issue, and it would be difficult to see how that would actually work. I think at least initially, given what the statute says, that the distribution plan has to involve all the parties. Now, Congress at some point could pass a statute that did all sorts of things. But that's an important thing to kind of ask and find out. Are these 8 tribes, are they really all on the same page? Do they all agree that they do not want the money unless it comes in a separate statute in which there involves land return? And land return itself would be very complicated given the fact that it wouldn't be returned to one entity because the Sioux Nation of Indians doesn't exist. So land return would raise the question, land return to whom? Which tribe? Or would there have to be a new separate legal entity that could be the authoritative manager and owner of that returned land? So the fact that the Great Sioux Nation is now 8 discrete tribes raises some very important questions that I don't think the ready answer is actually there. But that's an important thing. And I myself am unaware, but have these 8 tribes, have they had discussions among themselves about how they kind of see this? And that's just another complicating fact that I don't think the secretary has had to confront, where the original single solitary plaintiff is now 8 discrete tribes. Just makes all the more sort of complicated.
Thank you. Another question that we received is, what are your feelings on the 2020 McGirt decision? And did that give you encouragement that you might see the 1980 Great Sioux Nation judgment be resolved, either momentarily or some form of land return?
Well, I guess my own reaction is the McGirt decision is very important, but it's in some ways completely different from the issues, the way I see it in the Black Hills case. Because the fact in the Black Hills case, the Sioux Nation has prevailed. It's just a matter of, easily said than done, of fashioning the appropriate remedy. And the original appropriate remedy was only money. And I think the individual tribes made it clear they didn't want just the money. It wasn't that they didn't want the money, but they just didn't want the money without some kind of land return. And so I think the McGirt decision is kind of in the background, at least for me, about the Supreme Court kind of doing the right thing. And maybe that can provide some impetus that this is worth talking about, that maybe Congress, when confronted with a different statute that had strong support by these 8 tribes, and presumably a good deal of the population here in South Dakota, to say, we recognize that this wrong was done, but there's still a chance to have justice because there is an avenue and a vehicle for land return and a vehicle for money, and that through creative, legal, and cultural thinking and working together, that a bill can be fashioned that I think meets the kind of difficult goals that are out there. But it's not going to happen, this is just my opinion, unless people become informed, talk about it, be honest, try to see if you can come together with a new proposed statute, because that's what it would take. It would take a proposed statute to go before Congress that could effectuate a money settlement and land return and lots of other complicated issues. Because just to return the land in and of itself has a knot of important legal questions. Return it to whom? Return it in what way? It's going to be kind of trust land under Indian law principles. Who's actually going to be able to govern that land? What are going to be the purposes for that land? So there's a whole cluster of very particularized questions about land return itself. But I think the first big question is, can there be a coalition of Native and non-Native people and the tribes about how to go forward? And I am optimistic that that's possible, that people put their hearts and minds to it. And I think the land acknowledgement process is kind of a small opening that can become a vehicle, at least in the non-Indian community, about providing situations, opportunities to discuss the Black Hills case, because in my opinion, 40 years plus after the decision, I do not think that the general non-native population is well informed about the history of the case and what's happened since 1980. Take a lot of work, not impossible, but a lot of work to discuss this, to help people become informed. I guess I would use the term literate, to help people become literate about this issue, because it's very complicated, both politically and legally, and people have to be willing to do the work to kind of become informed about it. And I believe that it can. And I believe maybe that this land acknowledgement process provides a vehicle and a platform to generate these kind of necessary discussions.
The next question that we received is, if the Sioux Nation of Indians were to receive the remaining 1.2 billion acres of land that are held by the federal government, would they accept/receive compensation for the land not returned to them?
Well, that's open for discussion. I think it's 1.2 million acres. I think you might have said 1.2 billion acres. So it's 1.2 million acres. And it's just because this all would be in the hands of Congress. And Congress definitely would have the authority, does have the authority, to pass a bill in the context of the Black Hills Act that would effectuate the return of land and a certain level of compensation. And just like any piece of legislation, I think there would likely be sort of discussions and negotiations around how much compensation, how much land would be, from the Lakota point of view, adequate and fair. How would the federal government see that? How would the people of this state see that? I don't think there's an absolute this much and no more. It's a matter of good faith negotiating, try to reach a consensus of what everyone thinks is fair on both the land return and compensation, and getting that bill before Congress with a lot of support from the Great Sioux Nation, from non-Native people, to convince Congress that this is where justice lies.
That is all the questions that I have received right now. If anyone has any additional, they can feel free to either unmute themselves or add it to the chat.
Yeah, I mean, and I would just add that, it takes, in my opinion, is like a tremendous amount of work that's involved, particularly on the land return component, is like, first of all, identifying how much land, what land, what would be the legal status of the land that was returned. Would the bill passed by Congress specify how that land was to be used? Who would actually govern that land? There would be sort of jurisdictional issues. And once you get agreement about, yes, land return, then there's at least a half a dozen subsidiary, practical, on the ground, tricky legal questions that I believe would have to be resolved in pending legislation before you could effectuate a meaningful and lasting land return. Maybe it makes sense, maybe through the Secretary's Office, Secretary of Interior, Secretary Deb Haaland, to appoint a committee or a commission to be looking at the Black Hills issue and charging them with the responsibility of coming up with recommendations in the context of compensation and land return and all these subsidiary land return questions, to get something out there that had vigorous input from Indian country, or something that people could actually begin to look at. Is this is what some people are thinking, and to begin to transfer just the thoughts into some kind of document that could provide maybe ultimately the basis for a proposed statute. It's a tremendous kind of challenge, but I think, and I'm not speaking for any Lakota people, they've been in the struggle since land was taken in 1877. So they know what the long haul is like. And I'm just trying to suggest that maybe this is an opportune time to push that discussion forward in a meaningful way. If people are up to the challenge, particularly in the non-native community, it's kind of like it's a bit of a challenge to them, saying like, well, you have this land acknowledgement statement that you're interested in these issues, and well, let's see how interested you are, how much you're willing to learn, how much you're willing to commit your own thinking and resources to trying to achieve justice. Because the overarching thing, I think, to remember is to achieve justice. Yes, it's the practical things about money and land return, but for what purpose? And I think it's important to keep in mind, particularly from the non-native point of view, that this is an opportunity to still render justice in this case. You know, oftentimes when there's injustice historically, you don't get a second chance to right that wrong or to try to improve the situation going forward. And I believe, and I've always believed, that in the context of the Black Hills, there is this second chance because there is land available to be returned. There's certainly money for adequate compensation. There's an opportunity that historically oftentimes doesn't come along once an injustice has been committed. And so I think people, particularly in the non-native community, need to realize that this second opportunity is fortunate. It's a challenge. It's a blessing. We need to try to take advantage of it, become knowledgeable about it, do the work.
Thank you, Professor Palmersheim, for your wonderful presentation today. I am sure, like many, that they learned a lot. I learned a lot as well. If anyone has any additional questions that they did not want to ask today or they think of later, please contact the State Bar at info@statebar.net, and we will try to get your question to Professor Palmersheim. On behalf of the State Bar of South Dakota, thank you for all those in attendance for joining us today, and have a great rest of your day. Thank you.